Hello, and welcome to another episode of the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. I'm Deepa Taylor. In this podcast episode, we delve deep into family and divorce law here in Ontario, providing you with the knowledge you need to navigate these complex and often emotional issues. Today, we're going to walk through a critical topic, the 5-step process to a successful divorce. This episode is designed to give you a clear roadmap of what to expect if you find yourself at the beginning stages of a divorce. We'll break down each step so you can approach the process with a sense of understanding and control. Before we dive in, please remember that this podcast is for general informational purposes only and should not be considered legal advice. For personalized guidance, please consult one of our lawyers by visiting DivorceLawyers.ca. The first step in the divorce process is often the hardest, making the decision to proceed with separation. This is a significant emotional milestone, but it's also where the legal process begins. Once you've made the decision, you have two main routes to consider: working towards a separation agreement or commencing a court application. Let's break that down a bit more. If you and your spouse can agree on the terms of your separation, you might be able to draft a separation agreement. This is a legally binding document that outlines how issues like property division, child custody, and spousal support will be handled. However, if you're unable to agree, or if the situation is contentious, you may need to start the process by filing a court application. This application is crucial because it officially initiates the divorce proceedings in the eyes of the law. When filing, you'll need to consider the jurisdiction. For instance, if you have children, the court should be in the area where the children primarily reside. If there are no children, you'll typically file in the jurisdiction where the family's main property is located, such as the matrimonial home. You'll also need to decide whether you're filing for a simple divorce or if you're addressing all related issues, such as property division and support, in your application. These decisions set the stage for the entire process ahead. Once you've filed your application, the next step is to see how your spouse responds. After being served with the application, your spouse has 30 days to file a response. This response will give you an indication of whether the divorce is likely to be contested or if there might be room for negotiation. If your spouse disagrees with your claims, they'll outline their own demands or defenses in their response. This is where the tone of the divorce process can be set, whether it will be cooperative or contentious. After receiving the response, you, as the applicant, have 10 days to file a reply if there are any points you disagree with. This exchange of documents, known as pleadings, lays out the groundwork for the case and is what the court will refer back to throughout the process. It's important to remember that during this step, all the issues that will be addressed in court, like parenting arrangements, financial support, and division of assets, are clearly laid out. This is also where you might see some of the more personal and painful aspects of the divorce come to the forefront, such as disagreements over income, property, or child custody. With the initial pleadings out of the way, the next phase involves attending court conferences. These are mandatory meetings that help the court manage the case and encourage settlement before a trial becomes necessary. The first of these is the case conference. This is generally more procedural and is meant to help both parties and the judge get on the same page. It's also an opportunity to address any outstanding issues, like missing financial disclosures or preliminary agreements on certain matters. After the case conference, if the case is still not settled, a settlement conference may be scheduled. This is a more in-depth meeting where the judge will give their opinion on how the case might be resolved. The goal here is to find common ground and possibly reach a settlement without going to trial. Finally, if the case is headed towards trial, there's the trial management conference. Here, the logistics of the trial are discussed, such as the number of witnesses, the issues to be addressed, and the expected length of the trial. This stage is critical for making sure everything is in order before the case goes before a judge in a full trial setting. Step 4 in the divorce process involves bringing motions. A motion is essentially a request to the court to issue a temporary order on a specific issue before the trial. For example, if you're having trouble getting financial support during the divorce process, you might bring a motion asking the court to order interim support payments. Before you can bring a motion, however, you must attend a case conference. This is to ensure that the motion is necessary and that all other options for resolving the issue have been exhausted. Motions can address various issues, from child custody to property use, and they can be critical in managing the day-to-day realities of life while the divorce process is ongoing. They also serve as an important check, ensuring that one party doesn't unduly delay or complicate the process without consequences. Remember, the court can impose cost penalties if one party is found to be acting unreasonably. The final step in the process, if you haven't been able to settle, is preparing for and potentially going to trial. At this stage, all efforts to resolve the issues through negotiation or mediation have failed, and a judge must make the final decisions. The trial process begins with the settlement conference, where both parties are required to submit offers to settle. The judge will review these offers and try to bridge any gaps between the parties' positions. If no settlement is reached, the case is placed on a trial list, and the trial management conference is scheduled. This conference is crucial as it sets the stage for the trial, deciding on the issues to be tried, the witnesses to be called, and the amount of time needed. During the trial, both sides present their evidence and arguments, and the judge makes the final decisions. This process can be emotionally and financially draining, which is why it's often in everyone's best interest to settle beforehand if possible. But if you do go to trial, having a skilled lawyer by your side is essential to navigate this complex process. And that wraps up our discussion on the 5-step process to a successful divorce. I hope this episode has given you a clearer understanding of what to expect if you're facing a divorce. Remember, while this process can be challenging, being informed and prepared can make all the difference. If you have any questions or need legal advice tailored to your situation, don't hesitate to reach out to us at DivorceLawyers.ca. Our team is here to help you navigate this difficult time with the expertise and compassion you deserve. Thank you for joining me today on the Divorce Lawyers podcast. If you found this episode helpful, please share it with others who might benefit from this information. And don't forget to subscribe so you never miss an episode. Until next time, take care of yourself and stay informed. This podcast was brought to you by DivorceLawyers.ca. For more information on family and divorce law in Ontario, visit our website and schedule a consultation. See you in the next episode.